I like to call it control from the grave. Do you know when you're going to pass away and go see the good Lord? No, you do not. Hello and welcome to SWBC's Uncharted Wealth Podcast, where we simplify the complex financial topics and break them down in easy to understand terms so that you can navigate your financial journey with confidence. My name is Mike Walters. I am a wealth advisor and certified financial planner here in SWBC's Wealth Management Division. Whether you're a returning guest to the podcast or today's your first episode viewing in, we want to thank you for joining us, and I hope you learned something. Okay. Now, no one likes to talk about death. You're like, Mike, well, we just talked about death and life insurance in the last episode, but today we're going to be talking more about estate planning. And from what I find, not a lot of people like to talk about that. Okay. They don't want to think about what happens after they're gone, but the truth is, if you don't plan, what happens, it can create a lot of stress. It can create a lot of confusion, and leave some financial hardship for your beneficiaries. So do you need a will? Do you need a trust? Do you need power of attorney documents? Maybe you need all of the above. I'm going to help you try and make those decisions today so that way you don't leave somebody holding the bag at the end. I'm going to dive into the estate planning basics, what wills and trusts do to protect your wealth, and common mistakes that could cost your family time and money. So the first section today is understanding wills and trusts. Okay, so I first want to start off by saying, what is a will? Okay, a will is a legal document that directs how your assets should be distributed after your death. I like to call it a ticket. It is your ticket to go to probate, which, if you don't know what probate is, it is a process that verifies and executes what your will says. So if your will says, I want to leave my money to my kids, you're going through that probate process is where, the person that is in charge of your estate is going to go through the process, and they're going to validate your will and say, okay, so-and-so does want their assets to go to their kids, so on and so forth. Okay, that's a probate process. It could also name guardians for your minor children. Okay, so if you have minor children under the age of 18, or maybe you have dependents that cannot care for themselves, like if they are disabled or elderly, that is the same thing. Your will is determining, who is supposed to be in care of those dependents. Now, in regards to a trust, and here's where it's going to be different. Whereas a will is a legal document, a trust is an actual legal entity, okay? And it will hold your assets and distribute your assets outside of the probate process. Now, a trust can take effect during life, which is where you hear a living trust. If you've ever heard that before, that's what it means. Your trust is active while you're alive. Or there's something called a testamentary trust, which means it does not activate until you have passed away. Okay? Now, the trust is going to be the key here, because a trust will give you more control of how and when your assets are distributed after you pass. I like to call it control from the grave, and we'll go into some of those scenarios. Okay, now key factors in choosing whether you need a will or a trust could be how complex your estate is. Do you have a desire to avoid probate? Now, I'll be fully honest here. Texas, the state of Texas, has one of the least complicated, least costly probate processes compared to some of the other states. However, that does not necessarily mean when you pass away in Texas, if that's where your estate is going to be probated, doesn't necessarily mean yours is going to be easy or simple or inexpensive, right? So, do you just have that desire to avoid the process altogether? Another thing that you should definitely think about is if you leave money to somebody through a will, if that probate process goes smoothly and finishes successfully, all the money that you leave behind to them is just immediately theirs. They can do whatever they want with that money. It's on them, right? What a trust can do, however, is you can put stipulations in that trust as to when they receive the money, how they receive the money, if they have certain qualifications they have to meet. So, for example, we have a lot of clients who, when they leave assets to their kids, they put a stipulation in there that maybe they can't access a certain portion of the money until they're 35 years old. And then they get some when they're 40, and then they get some when they're 45, or something like that, right? You could also put things in there such as, if you feel like your kid or grandkids or whoever you're leaving the money to, maybe have gotten into some trouble with the law, and you want to say, hey, they have to be clean and sober for X amount of months. They have to be able to pass a drug test, or yes, this money is for them, but you assign somebody else to determine when and how they can get that money. You can do all those stipulations inside of a trust, where you cannot do that in a will. Another thing trusts do exceptionally well with protecting generational wealth is keeping it ex-spouse protected. What does that mean? Well, we're in a community property state of Texas. So what that means is anything that you own with your spouse is going to be owned 50-50. Now, let's say that you leave behind some money to your kids, or let's just say you have a son for right now. Okay, let's say you have a son, and your son gets married. Now, however good relationship that you have with your daughter-in-law, okay, really ask yourself, hey, if something happens with your son and her after you're gone, do you really want her to have some of the money you left behind for your son? Okay, probably not, right? If you leave it to them in a will, your son takes that money and puts it in a joint bank account, whatever, guess what? Half of that is going to be probably split between the spouse if they ever get, split up, right? We don't say the divorce. We don't like to say that word around here, but if it ever happens, that's what's going to happen. Now, if you do it with a trust, leave behind money to your child in a trust, and as long as that money stays in the trust and they split with their spouse has no claim to the assets that you left for them. Now, I have a daughter. She's only 2 years old. I already do not like my future son-in-law. I don't like him, okay? Now, do I want my future son-in-law to potentially have access to the money that I leave for my daughter? Nope, okay? If something were to ever happen with them, that money is to stay with her and to go to any potential grandbabies, okay? But again, ex-spouse protection. It's a good thing. Another reason to want to have a trust is that it gives you privacy. Whereas wills, you go through the probate process, it's all public information. I can go onto the county's website. I can see exactly what you leave behind. A trust is private. Only the people involved in the trust will know what's going on. There's actually there's a lot of famous people who actually died with a will, but today, for example, there's a very famous singer, and we're going to put some R-E-S-P-E-C-T on her name, Aretha Franklin. She died with a will. She had about $18 million in her estate, I think, when she passed away. But she had multiple wills, which created a bunch of confusion. Her sons fought over it. There was not clearly outlined who's getting what. And anybody like you or me can go onto the website and see exactly what her will said. So if you have the want of keeping everything private, a trust is going to be the way to go. Now, speaking of avoiding a probate, now trusts are very good at that because everything is kept private, but they also are very good about protecting generational wealth, okay? Now, they also will minimize estate tax issues by avoiding probate. It's going to save time. It's going to save possible legal fees. And again, it ensures that your assets are going to be distributed to the beneficiaries or whoever you want to receive your assets after you pass. And also, it can protect the assets from creditors and lawsuits. Okay, so as long as the assets stay within the trust after your passing, call them ambulance chasers. They can't come after your money, seeking medical bills and stuff like that. Now, here are some other simple estate planning strategies that anybody can use. Payable on death, a POD, if you ever heard of that. Or there's something similar called a transfer on death. Now, this is just an account or a way that you can register your account, like an investment account, where it's basically naming your beneficiary outright, so it automatically bypasses the probate process. So, example, if you have a bank account that has a payable on death attached to your spouse or your kids, that account will automatically avoid the probate process. If you have a retirement account where your spouse or your kids are listed as the beneficiary, that will automatically avoid the probate process, okay? Another way to do that is to retitle your property into a trust if you have one. So I'm thinking about taxable accounts like brokerage accounts, or maybe even your real estate, your primary residence, okay? Here is an example of why it's important to have your primary residence in the name of a trust if you're married, okay? So in this example, let's say you and your spouse own the house. Both of your names are on the deeds, and your spouse passes away, okay? Now, maybe you don't want to keep living in that house, or maybe you want to go and live closer to your kids, or there's too many memories in that house, or maybe you just want to refinance. I know now is not a good time to refinance, but maybe the mortgage is at a high rate, interest rates come down, and you want to refinance. Well, what do you do if you want to do any of those things and your deceased spouse is still on the deed? Well, you have to go through the probate process to remove them from the deed first. And again, that takes time, could take money, we're trying to avoid all that. So, husband and wife puts the ownership of their house into the name of their trust. Now, they're still the primary trustees. They can still make decisions on whatever they want in that trust, but the trust owns it. So, in our example, when your spouse passes away, because that spouse that remains living is still the primary trustee and can make decisions however they want, that means they can refinance, they can sell the house, they can move, they can do all those things without having to go through the probate process. So it's another very powerful way to ease the process when someone passes away, is retitling their assets into the trust. Now, something else to think about are gifting strategies, okay? A lot of times when clients are telling me their estate plan wishes, they have X amount of money going to their kids, X amount of money going to charities, so on and so forth. Well, if you have a financial plan in place and it looks like that, you're not going to run out of money in retirement and you're going to potentially leave behind this huge estate, what benefit can you get to see your beneficiaries actually enjoy the gifts that you give them? Okay, so instead of passing away and leaving your money behind, you don't really get to see them enjoy that benefit of getting those gifts, or if you're going to give it to a charity or your alma mater or something like that. I know a lot of people don't do this for the recognition or anything, but maybe they want to put your name on the library or something. I don't know. But even if it's just giving money to your kids or something, maybe they're going through a time in their life where they could use a little extra help. Well, why don't you gift them while you're still alive and really reap the benefits of doing those charitable contributions? The last thing that anybody can do, and this is probably the most important thing to do, we do it with our clients at least once a year, is just reviewing the beneficiaries on all their accounts. Life insurance, investments, banking accounts, 401ks, employer-sponsored plans, like just making sure that your beneficiaries are updated, because the last thing you want is for something to happen and you end up leaving money behind to somebody you didn't want, like maybe your ex-spouse. No, we don't want that. So just reviewing your beneficiaries periodically, like I said, at least once a year, is get in the good habit of doing that, right? And anybody can do it. Now, some estate tax considerations. Right now, the estate tax limit is like $13 million per person. So double that for a couple. If you're not planning on leaving behind more than $13.6 million for an individual, or double that for a joint family, then you really don't need to worry about estate tax implications right now. However, just like everything else in our tax code, those things can change over time, right? The estate tax exemption did not used to be that high. So you want to make sure that you are still kind of looking ahead to seeing, hey, what if they change these tax laws? What if these exemptions drop? Maybe there should be some different opportunities that you can be taking advantage of to possibly lower the estate taxes that could be levied upon you after you pass away. Which brings us into our uncharted territory for today, which are the common misconceptions about having a trust in your overall estate plan. So, first one I hear all the time is, well, I don't need a trust, I'm not wealthy. Well, you don't have to be wealthy to have a trust. Look at me. I'm wealthy because I love life and have a beautiful family, but But wealthy, you don't have to have a lot of money to have a trust, okay? The reality, trusts are useful for avoiding probate no matter what net worth you have or leaving behind. They're good for protecting assets and ensuring that you have that smooth transfer of the assets when you pass away. The second thing I've heard multiple times actually in the last year, is that they think trusts have an ongoing cost. Now, most of the time, especially these living trusts, these revocable trusts, there's usually no costs associated with keeping those things active, right? Usually you are paying an upfront cost to have the documents originally executed, but unless you have a professional trustee or some kind of portfolio manager that's managing the trust assets, there's usually no ongoing costs, okay? So anything above those upfront costs, you're usually not looking at ongoing recurring fees. Third thing is, which actually has come up a lot in the past, especially because I'm in Texas and this is a community property state. They're like, oh, my spouse is just going to inherit everything anyways. Well, yes and no. Different states have different tax laws. Be mindful of what's going to happen with your current state. You know, if you pass away in Texas, you pass away somewhere else, and where your trust is actually, what laws are actually governing your trust documents. Now, without a will or a trust, guess who decides where your money goes? I'll give you a second to think about it. The government. The government decides where your money goes, okay? Same thing with guardianship. So if you don't leave something behind, like a designation of guardian in your will or in your trust saying, hey, I want my, brother or sister or this person to take, guardianship of my kids, the state is going to decide who is going to look over your kids. And I don't think that's something that, I want the government to take care of my kids. No, you don't. Choose somebody that you know and trust. The last misconception about not doing a trust is, I'll do it later. I have plenty of time. Really, bro? Bruh. Do you have a lot of time? Do you know when you're going to pass away and go see the good Lord? No, you do not, okay? So procrastination can lead to those unnecessary legal battles, unintended heirs, and family disputes. Like I said, Miss Franklin left behind this huge estate. She had multiple wills. Her sons actually fought over who was going to get what. And you know what happens during that probate process? Not one dime of that estate can be withdrawn to anybody until that whole legal battle is done. So do you really want to put that on your family or those that you're leaving behind? Probably not. So my key takeaway for today, that you should think is also your key takeaway, is that estate planning isn't just for the wealthy. It's for anyone who wants to protect their loved ones and their legacy, okay? A will or a trust is a key part of any financial plan, and a lot of times, I think both is necessary in a financial plan. We are capable of doing estate planning recommendations here. Just to note, we're not attorneys. We're not estate planning attorneys or lawyers, so we can't technically provide legal advice, i.e. that's why we have disclosures at the end of every episode. But we can talk through some of these common scenarios, listen to what your estate plan wishes are, and kind of point you in the right direction as to what documents and what entities might be best for you to achieve your estate planning goals. Now, I'm going to encourage everybody that if you don't have an estate plan, even if it's just a will, to start talking about that. Start talking with your spouse or talk with your parents or, maybe somebody that has kind of gone down this path before. Ask anybody that has had to go through the probate process, and I'm probably willing to bet that it was not an enjoyable process. Not even, talking about the fact that they lost a loved one or a friend, but having to deal with potential disputes during the process, not being able to access the money during the process like that. That is just something that I would not wish on anybody. So start looking at what your options are. Talk to either a financial advisor who's capable of estate planning conversations, or seek out an estate planning attorney. There's a lot of great ones. You just got to put in the work to do your research, and then just make sure that your wishes are protected, okay? You're not just protecting your assets while you're alive, but we want to protect your assets once you're gone. So I want to thank everybody for joining us for today's episode. This was the sixth episode that we've done so far, and I feel like it's going by forever, but listen, we're glad that you were here. We hoped you learned something. Do not forget, you have to do this, okay? You have to go to our social media websites and like, comment, subscribe, share it with your friend, your brother, your mom, and your grandmother, okay? Because they want to see this content too, okay? If you want to contact me, give me any feedback, I would really love to hear some feedback from the listeners. I've heard it throughout the halls of SWBC of other employees that have enjoyed the podcast so far, so that's great. Thank you for that. But I'm also wanting to hear from clients and prospects, anybody else listening to this. So to close today off, do not be a silly goose. Do your estate plan or talk to somebody about it. Again, financial planning and legal advice, none of this is to be taken as that. These are all my opinions, nothing to be, this is not SWBC's opinion or of any of the other employees. This is purely just Mike Walter's opinion. Make sure you listen or read the disclosures at the bottom, and we will see you in 2 weeks. Bye.
Investing involves certain risks, including possible loss of principal. You should understand and carefully consider a strategy's objectives, risks, fees, and expenses, and other information before investing. The views expressed in this commentary are subject to change and are not intended to be a recommendation or investment advice. Such views do not take into account the individual financial circumstances or objectives of any other investor that receives them. This information should not be considered a solicitation nor a recommendation of an offer to provide any service in any jurisdiction where it would be unlawful to do so under the laws of that jurisdiction. Past performance is no guarantee of future results. Please consult with your individual tax professionals and/or attorney for additional information.